Hi everyone, my name is Jason Eisberg. I'm an associate family lawyer at Russell Alexander Collaborative Family Lawyers. Welcome back to our channel where we post videos about recent family court cases and several other interesting facts related to family law. Please subscribe and turn on the bell notifications so you don't miss an upload. Today we are diving into Family Law 101. What is a spouse anyway? Many of the videos we've posted over the years cover the family law disputes between spouses. But while those cases tend to have unique facts, they require and involve a baseline common understanding of what a spouse is under Ontario law. So today's video will go back to basics on that discrete point. Under the Ontario Family Law Act, the term spouse has its own built-in definition. That legislation, which deals primarily with various property rights between married and unmarried partners, defines the term in its section 1.1 to mean either of two persons who are married to each other or have together entered into a marriage that is voidable or void, in good faith on the part of the person relying on this clause to assert any right. This encompasses legally married couples of any gender, but excludes those who are unmarried, even if they qualify as a common law couple. However, specific portions of the Family Law Act, namely Part 3, support obligation, contains a broader definition that encompasses those common law unions for specified purposes. This Family Law Act definition of spouse is an important one, because for those who fall under its purview, the Family Law Act applies to their situation for the purposes of dividing property, determining spousal support entitlements, and the treatment of the matrimonial home. As the definition itself makes clear, the marriage ceremony can be irregular and fail to comply with certain legal requirements, yet still give rise to a spousal relationship between the participants. Specifically, even if the form of the marriage they went through was voidable, or even legally void, they can still be considered spouses for Family Law Act purposes. The key is that the participants have acted in good faith in undergoing the ceremony. With that said, the prerequisite for a valid legal marriage is a strict one. In a case called Kawartha v. Abdallah, the couple underwent a purely religious ceremony with no civil ceremony component, and the court concluded it was not valid under the Marriage Act. By extension, this meant they were not spouses for Family Law Act purposes. It may be a little known fact that even polygamous marriages can count under the Family Law Act for these purposes, since Section 1.2 of the Family Law Act provides that spousal status can arise even from a marriage that is actually or potentially polygamous, provided it was celebrated in a jurisdiction whose system of law recognizes the marriage is valid. This may be surprising, but it falls in line with the observation in a case called Concord v. Talui, where the court noted that the spirit of the Family Law Act is to widen the traditional grounds under which spouses share in the financial rewards of their relationships. On the flip side, once married former spouses, i.e. those who are already divorced, do not count as spouses under the provincial legislation. In a case called Jahangiri Navane v. Tahiri Zengakani, a former wife's application for spousal support under the Family Law Act was rejected since her foreign divorce left with a non-spousal status at the time of her application in Ontario. Finally, it's important to know that this definition of spouse in the Family Law Act is not universally applied across Canadian law. There are unique and tailored definitions found in other provincial legislation, like the Insurance Act, and in federal legislation such as the Divorce Act and the Income Tax Act. That's it for today's video. Please give it a thumbs up. We look forward to hearing your thoughts and feedback in the comments below. Please subscribe and hit the bell so you don't miss our upcoming videos. Thanks for watching.